Our keynote speaker is someone who needs no introduction, so I'm wondering why I'm up here. But I'll tell you a little bit about his background, because I think it's important that you understand it. He was a Marine officer. After he finished his stint in the Marines, he went to Columbia University Law School. He did a short stint at a New York City law firm, and then went on to the United States Department of Justice in the tax division as a trial attorney. Later in his career with the Federal Department of Justice, he was called upon to manage the administrative functions of the United States Department of Justice. This was a recognition of his incredible skills and insights into how large organizations function and how they could function better. He was appointed by the Supreme Court of the United States to be the director of the Administrative Office of Courts. He later was recruited by Chief Justice Berger, and he was one of the founders of the Institute for Court Management. And you all understand ICM fellows? Well, he was the original fellow. And he is a legend in the area of court management. He was a senior Fulbright scholar. He was a dean, he was a professor of law at multiple law schools, a dean of 2 law schools, and was the first dean at the National Judicial College, again, recruited. I say that because when someone changes jobs as often as Ernie did, you think, well, this is somebody who can't hold a job. But he left jobs because he was constantly recruited to more interesting and challenging opportunities. He has consulted throughout the world, the United Kingdom, Australia, Kenya, Russia, Jordan. He is called upon constantly to give his insights into the functioning of court systems. And it is my particular honor to present to you for the keynote address this morning, Professor Ernie Friesen.
I can hardly wait to hear what I have to say. You will notice that my voice is not what it might have been some time ago. I warn you, I have never read a speech before. I have spoken hundreds of times, but I don't trust myself to find all the words and remember all the names that I once did. I'm going to try to speak very softly. So you're going to have to listen very carefully. And it may be that that's the kind of a message I would like to deliver, one that you have to work a little bit with me to get it. I graduated from law school in 1955 and joined a New York law firm. In my first week there, I was handed a large but simple estate to take through probate. As any intelligent young lawyer would do, I followed the format from a case in the office that had recently been successfully completed. I prepared the papers, got a check to cover the fees, and proceeded to the surrogates court in Manhattan and laid the papers on the counter. The clerk picked them up, he turned them over, then he turned them back over and told me they were unacceptable. Somewhat chagrined, I asked, "What's wrong with them?" And he told me that I was a damn lawyer, I should know that. So I went back to the office and spent the rest of the day comparing my efforts with those that had been accepted before. Finally, embarrassed, I went to see the partner in charge. And he laughed, told me to attach a $5 bill to the back of the file and take it back. Returning to the court, the clerk found the $5 bill, put it in his pocket, and accepted the filing. The $5 would, adjusted for inflation today, be about $50. The point of this story is not that the system was corrupt, which indeed it was, but that everyone knew about it and accepted it. Since that time, I've had many years of experience in and around the courts of the United States and 10 foreign countries. I continue to hear about this kind of tolerance of malfeasance. And when I first hear about such things, I admit to thinking like a lawyer, why don't they throw them in jail? But when I think like a manager, I ask, how could the system have been managed to avoid that kind of a problem? The answer is that a comprehensive, conscious awareness of how the many court processes work would prevent that kind of thing from happening. Today, I shall ask you to consider what would be involved in establishing such a comprehensive approach. An approach that will at the same time promote the integrity, fairness, and interdependence of courts in the state. In doing so, I am going to assert that the existing governance systems in our state courts are grossly out of date, and that there are in existence examples of a better way to do things. Let's start this examination by acknowledging our roots in Magna Carta, which 800 years ago provided the first break in the absolute divine right of the monarch to commission judges and to control their decisions. Though not applicable to ordinary people, the peers of the realm in Magna Carta negotiated the right to be an independent, or to have an independent adjudication of claims made against them or for them. It took 4 more centuries before the ordinary Englishman had a right that these peers of the realm claimed in Magna Carta. And of course, it took another 150 years for the colonists to claim those same rights for themselves. Today, we trace our concerns about judicial independence to specific grievances recited in the Declaration of Independence, which reads, "The king has obstructed the administration of justice by refusing to assent to laws for establishing judicial powers. And the king has made judges dependent on his will alone for the tenure of their offices and the amount of payment of their salaries." These repeated grievances led to the inclusion in our U.S. Constitution of Article 3 that created an independent judiciary. Today, I ask you to consider whether this centuries-long struggle for judicial independence is being fully realized in the United States. Whether the machinery put in place to preserve that independence fully supports the victory over executive and legislative interference. We don't have to look far to find that there is still a good distance to be traveled. Municipal and other local courts are, in many states, a prime example. Let's just use the example of Ferguson, Missouri, where we have information published in the papers about their court. Before Michael Brown's shooting, in the city court system, the chief clerk of the court reported to the police chief, Court staff performed clerical duties for law enforcement and prosecutors, and the court bowed to pressures from city officials to generate fees and fines with very little regard for due process of law. In fact, no effective separate governance system existed between the court and the city and the executive and legislative functions. And no one at that county level or state level appears to have any concern about it. My proposition to you today is that the governance structure that now exists in most states are poorly designed to be comprehensive. And there are several reasons why they fail to cover the full impact of courts. Courts which are today a social force in our government. First of all, they depend upon fully engaged incumbent chief justices from their highest courts, who are designated head of the judicial branch. Second, the management activities within the branch are often ad hoc, responding to a current interest of the chief or a perceived crisis, rather than for court purposes. And third, the government structures that exist are irrationally centralized. I'm about to wade into dangerous waters. I'm about to suggest that chief justices, with or without the approval and participation of their courts, are not the best choice to make the critical decisions required to govern a modern judicial system. I expect to be misunderstood, what I'm about to say, but ask a few of you to listen carefully when I say that I believe our state Supreme Courts are supremely competent at the work they historically have taken on. They maintain a uniform application of justice in the cases brought before them. They are fulfilling the single most critical function of any justice system by providing timely and clearly explained interpretations of law. You suggest, as I do here, that they are not qualified to govern a complicated system of judicially based activities is to recognize that courts serve a much larger purpose in the scheme of government than they did when the systems of governance now employed were designed and adopted. The fact is that judicial competence and governance skills are not the same. In many respects, they are contradictory. Lawyers value individual behavior to the exclusion of teamwork. When they become judges, they continue, as they should, to value their autonomy of efforts. Managers working to coordinate group effort must build collaboration and lead teams. It has been astutely observed that lawyers in general, and judges specifically, tend to judicialize all decision-making. That is, they create a hearing at which the evidence is presented, arguments are made, and after a fair hearing, decide what should be done. Once reached, the decision is only one more step removed from res judicata. Effective managers, on the other hand, constantly weigh alternatives, continuously collect and assimilate information, and are able to adjust their courses as conditions change. The law needs finality. Management needs flexibility. Judges and lawyers, as advocates of law, believe rules solve problems. Authority exists to be exercised. If something is wrong, adopt a rule and enforce it. How many times in your career as a court manager have you seen a judge address a problem by deciding that the introduction of a new rule will solve the problem? The workload of modern Supreme Courts is a further impediment to effective Chief Justice governance. This appears in two ways. The first involves the limited number of issues the court has time for and leads to increased limitations on what can be heard by the court. This also leads to, in the high volume cases like collections, traffic, and divorce, with all their problems, that can't get to the high court. And this feeds into the tendency of Supreme Courts to understand and address only the problems which they experience. Probably more apparent to the people in this room than to anyone else in the judicial system are the conflicts of interest Supreme Courts face when undertaking to govern the diverse activities of a modern court system. Disputes over record authenticity, disputes about jury administration, disputes about the contents of reports, to name only a few, have one of two effects. Either the court must avoid critical administrative decisions, or they must become involved in unappealable legal errors. Many of these problems are left unmanaged to avoid the conflicts of interest. In the judicial history of the United States, there have been notable exceptions to the limitations that I have just listed. In my personal experience, which includes studying over 100 judicial operations and their chief judges, I can name only 12 who approached their duties comprehensively. Among those 12, most spent little time performing judicial duties. They either don't have time or they don't have the interest in being comprehensive. It may help to understand how the state judicial systems got to where they are. I was once introduced as a person who didn't need to study history because I remembered it. American courts 100 years ago, and that's not included, were a collection of mostly local entities managed at a county or city level, if at all, by elected clerks who were responsible for keeping the records and such scheduling of cases as might meet the convenience of the judges and the lawyers. For a judge to interfere with scheduling was heresy. The cases belonged to the lawyers, and the judges were not to interfere with what the lawyers thought should be done and when it should be done. If 2 or 3 judges sat in the same courthouse at the same time, they ignored conflicts in the schedules and operated independently of each other, with separate rules applicable in separate courtrooms. That condition, which I described as 100 years ago, was very much alive in 1960 when the changes started. To go back, your best recollection of what that was like, you probably could gain from reading about Abraham Lincoln, who rode circuit from town to town trying cases. The courts in 1900, which I picked specifically, weren't very much different from the way Lincoln practiced in the 1840s and 50s. Reform in the United States started very slowly And the thing that started it was a speech by Roscoe Pound, which you've all read. His speech undertook to widely, critically address the courts, the causes of popular dissatisfaction with the administration of justice. And you'll remember that one of his main points was that the courts were fragmented into overlapping jurisdictions with conflicting and archaic processes. Though Pound's remarks were suppressed by the American Bar Association, they didn't allow them to be published for several years. They eventually became the clarion call for the introduction of organization into the courts of the American system. More significant than this 1906 speech was the organization in 1913 of the American Judicature Society. Pound, who was then the dean of the Harvard Law School, was a leader of the movement for what was called sociological jurisprudence. He was a strong admirer of Max Weber, some people say who invented sociology. But there was a theory of organization which is best characterized by Frederick Taylor. And we refer to the theory as Taylorian management. He introduced scientific management. Scientific management and its organization wasn't about what the organization was doing. It was how to produce widgets better than anybody else could produce widgets. And in this theory, Taylor treated humans as parts of a machine. Taylor, after all, was an engineer who had designed machines before he got into organization. And that dominated all the reform movements of government and everything else in the 1910, 30, and mostly has been rejected by all management theorists today as a part of the management world. The Judicature Society, from its very beginning, advocated the unification of state court systems with the Chief Justice and the Supreme Court as its head. This Taylorian hierarchy of authority was adopted without dissent as the model to be applied in judicial reform. Now, you begin to get a sense of time here because Judica's position on this reform, though widely advocated constantly, had nothing happen or was not accepted for 35 years. In 1947, there was a judicial scandal in New Jersey. Several judges went to jail. And New Jersey, under the leadership of a lawyer who was president of the American Judicature Society, adopted this Taylorian model to create a judicial article placing the judicial power in the Chief Justice with some approvals from the Supreme Court. Now, though for reasons we don't know quite why, Vanderbilt and the people in charge did not include the city-county level of courts in the administration system which was adopted. Now, you think about Vanderbilt for a minute. Besides being president of the Judicature Society, he had been president of the American Bar Association. He had a direct phone line from his office in Newark to the House of Representatives of the state of New Jersey. He could pick up the phone and talk to people, which in that day was unheard of. He was a powerful man. And there's no doubt that his taking over of the judiciary when he was appointed Chief Justice of this new article was needed and was most successful. He cleaned up the mess. And he continued to run it in many fortunate ways. Of interest to all of you, of course, is that he hired the first professional court administrator in the United States. A court administrator who sat with the Supreme Court once a week to talk to them about the policies that needed to be followed through on, and who designed an information system that kept track of what was going on in the individual superior courts of the state. Chief Justice Vanderbilt regularly admonished all the judges and lawyers of New Jersey to read the Roscoe Pound speech once every year as they began a new year of court practice. He was dedicated to those ideas. Well, the culmination of this history was reached 14 years later. We did 35 years, then we did 14 more. In 1961, when the three leading judicial reform organizations, the American Bar Association, the American Judicature Society, and the Institute of Judicial Administration, joined together in a national effort to sell the New Jersey system to the rest of the states of the country. As a result of this series of well-orchestrated conferences that drew together the leading political forces in every state, the states, by constitutional amendment or statute, adopted, at least in theory, central administration by the Chief Justices and Supreme Courts. There were two major exceptions. That was Georgia and California. In California, in 1960, rewrote their Judicial Council law to change the direction that would go. Now, this history is necessarily oversimplified and incomplete. Sometimes when I explain to foreign judges how the American system works, I start with an explanation. I say, everything I say to you today is false. And it's also true, because with 56 jurisdictions and systems, you can make no statement that isn't true somewhere. And all of them are somewhat false somewhere. But my experience in working with court systems makes me think that my generalities are broad enough to include probably 90% of the people in the room if you were to describe your system. Well, in the late 1960s, after this effective justice program had been run, and the states had adopted at least an idea of central control, many factors came together that, I say, created the role of courts in society today. Prior to 1960, Los Angeles Superior Court was probably the only court that recognized it had all of these social tentacles out into the system. The other courts were going on blithely like they had for many years. In 1960, research about courts started. Money became available to do a lot of court research, most of it experimental, but some of it very revealing. The Federal Judicial Center was created. It was created to do research. The people who advocated it, which included me, had not thought of all the other functions that the Federal Center would take on. The National Judicial College was created. In the early 70s, very early 70s, the Institute for Court Management and the National Center for State Courts. We can imagine no 10-year period in the history in which so much has happened that focused on what courts do and how they do it. I submit your organization is a product that belongs in that list of things that happen. You have a national association that has what everyone says a profession must have. It has a theory of values. It has regular meetings. It has a recruiting system that brings into the system people that are needed. And it has an education program. For the first time, this process asked the question, why do we need courts? And the answer led to the now widely accepted statement of purposes. So, how do we get to comprehensive management? I finally get to the point. A comprehensive approach to management of any organization begins with the recognition of the purposes of the organization. A prevailing view of management is that management is a process, this is my point, by which an organization attains its organizational purposes. Lawyers usually like that definition because the first element recognizes process, and lawyers understand process. Managers like the definition because it puts an emphasis on goals and objectives rather than efficiency as the measure of effectiveness. Please consider with me now the two parts of that definition. What are the purposes of a judicial organization, and what are its processes? Both questions are important to an inclusive approach to how an independent court system should carry out policy within the judicial system. A review of the agenda of this meeting reveals how comfortable NACM is with the answer to the first part of the question. I need to have the first slide. Got it. Okay. I don't need to read these. They're probably mentioned in 10 or 12 sessions of the meetings here today. Those define a very broad social contract with the people of the United States. If we had time, I would ask you to list what you do on a routine basis, what you personally do to address these purposes. You might quickly respond that assuring access is fundamental to number 4. Would you be surprised to learn that protecting individuals from the arbitrary use of government power was described by the Supreme Court of the United States 200 years ago as the essence of Magna Carta? You would certainly recognize some elements of due process of law in every one of those purposes. Would you recognize that there are also management processes in every element of due process of law? Jury management is the heart of obtaining an impartial tribunal. Case management has multiple elements of notice. Interpreter management is critical to the right of confrontation and of compulsory process. We don't need to review due process of law to see that comprehensive government requires that legal awareness to be built into the process. With the challenge posed by the recognition of the purposes, we can quickly agree to the elements of legal process. But management process doesn't have an established vocabulary. The new question I would pose to you is, what are the management processes, activities, work systems that address the purposes? To answer that question, we need a different vocabulary. Let's start with the list of managerial behaviors and roles necessarily uncovered by the groundbreaking research of Professor Leonard Sales of Columbia University. Again, many of you have been exposed to this. Some of you may remember that Professor Sales introduced these terms into the vocabulary of court management by teaching them to the first 7 classes of the Institute for Court Management. The term case flow management is a direct product of studying the workflow relationships in minute detail. Court managers were introduced to workflow when Maureen Solomon, who was in that first session, chose the term in her pioneering work on case flow management. The audit work relationship has had some writers recently where they recognize that courts have little or no effective audit in the system. I doubt there is a person in the room that is not known of the activities of the court system, like my opening example of staff extortion that would have been discovered by inspection, audit. Like many other activities that reflect trading relationships, the kind that happen in courts are readily recognizable, but it's important that they be recognized as trading relationships that are part of a management structure. You all read in the news about the judges in Pennsylvania who scammed the juvenile system by sending children to lockups in return for payments to the judge. Those judges went to jail. Can you imagine that a system that is adequately monitored could have this blatantly distorted sentencing practice in the court if people were aware? It's been reported that everybody in those towns knew it was going on. Does a judicial system that doesn't have an adequate management process to follow up and find out? Understanding the value of these relational definitions is greatly enhanced by research Professor Sales conducted. They not only define the bulk of the working relationships regularly found in large, complex organizations, but can be seen as dynamic. We'll stick with that word for a minute. Without dwelling on them too much, this research showed that these management relationships and activities change without notice. If they were created because you wanted service someplace, you could anticipate that they may change. Service, he found in his research, tends to become audit. Audit tends to become stabilization. These things happen even though you intended for them not to happen. I'm sorry, I skipped the point. Service tends to become advisory. Advisory tends to become audit. Audit tends to become stabilization. Are those terms familiar to you? Do you have them intentionally designed into your system? Are you thinking about what we need here is uniformity, so we go to a stabilization? We're thinking here that we need to inspect and monitor, so you intentionally put it in. And then after you've put it in, after it becomes part of your system, you keep track of it to keep it from deteriorating into something else. Understanding the significance of these process relationships, we are led logically to ask the next question. Where? At what location should they occur? A design of a governance system requires that the policy board be aware of where these processes impact on the operation of the system. And this leads inevitably to an awareness of where the processes must be applied. I'll be dogmatic for a moment to make a point. Court systems, for the most part, act at the local level, in local environments. The governance of such local systems require a constant, reliable input that is amenable to understanding local conditions. The decision to centralize or decentralize management activities must be based on an understanding of the conditions on the ground, to use a military expression. I submit today that failure to apply important centralization, decentralization principles has been a constant impediment to effective court governance. There are well-recognized criteria that dictate where the management processes should be located. Of all the basic considerations that need to be taken into account, 3 stand out. Economies of scale. It is often clear that advisory relationships need to be centralized simply because the cost of placing expertise at small locations is not feasible. Specialty services have the same limitations. With modern technology moving into courts at an ever-increasing rate, it is clear that experts can't be located at all locations. But the attitude of the expert toward their role can be thought out and managed. If service is intended rather than advice, the design of the technical department, a governance decision, must differ. And once it's installed, it must be observed to see that it doesn't change. Second, uniformity of policy. When the state needs uniformity of administration, the natural management solution is to set up a stabilization relationship, which can be located centrally, but with communication processes that make it possible to get permission quickly with a minimum of red tape. Red tape is usually a problem of trying to stabilize and not having the mechanisms to find out and get the permissions that are required by that process. Third, the location of work processes and relationships, which I think should dominate most decentralization issues. I provided a crude chart to suggest that the location of service, audit, advisory, stabilization relationships is a critical factor to be designed in. The most significant variable determined by location is the communication among the participants. Where do the processes of a judicial system take place? In a state capitol? In the Supreme Court building? These oversimplified diagrams make the point. At least 98% of the judicial work is local. If you look at court-related activities, 99% of the court-related activities are local. In this chart, if this chart accurately describes where your court work systems are, it illustrates the need for constant attention to the local communication system. I've spent almost 50 years studying case flow management. My unqualified opinion is that half of the problems can be solved in the courtroom by individual judges, staff, interactions, and lawyer communications. Half. Another 40% can be solved by reaction between the chief judge of the local court, the local bar collectively, and the heads of department in local government, like the prosecution and defense and other people. The last 10% of the problems of case management can only be solved by the leadership, the Chief Justice Office and the Attorney General's office, and sometimes the state police and other parts. But isn't it clear that those solutions require management processes? And those management processes are local. And the ability to solve their problems may need that from the very beginning. This is the greatest shortcoming of judicial system administration under the governments of a Chief Justice. When the propensities of the Chief Justice system are fully realized by the demands of state budgeting, local needs are often misdirected. In other words, the more central you get, the less attention is paid to local needs. And this is often compounded by a centrally devised and maintained information system that does not adequately meet the needs of the local relationships. I could name 5 states right now where the information system designed for budgeting purposes forgets the fact that they're also dealing with the administration of local courts, case management, social services, and all the other communications that take place. In all of these observations, I do not suggest that there is a uniform lack of awareness across the United States. For that matter, I'm here to acknowledge that some of the chiefs are ahead of the curve. Several chiefs have set up advisory panels representing a cross-section of the local courts. More importantly, I am here to showcase the products of 2 administrative systems that have directly faced the issues I have presented. Utah and Minnesota have both turned to the Judicial Council structure to provide a more comprehensive approach to the governance of their state system. Utah did it with a constitutional amendment, and Minnesota by exercising the Supreme Court authority to lead the judiciary. In each instance, the councils are not advisory organizations. They are policy-making, problem-solving governance groups that cause the judicial branch to be more pluralistic, interconnected, and collaborative. For the reasons articulated here today, it is a better way to govern state courts. Let me go ahead and introduce these 2 chiefs. Chief Justice Christine Durham has served on the Utah Supreme Court for 33 years. For 10 years, she was the Chief Justice. Her work as chief helped to revise the state's constitution to amend the judicial article by creating a unified system of governance for the judicial branch through a judicial council. The council contains representatives of each of the different kinds of court, appellate, district, juvenile, and justice, and is chaired by the Chief Justice. Chief Justice Kathleen Blatz of Minnesota and her colleagues on the court created a judicial council by administrative order. Chief Justice Blatz served as a legislator, district court judge, associate Supreme Court justice, and as Chief Justice for 8 years before retiring. Created by judicial order in Minnesota, there are 19 voting members and 6 non-voting members on the council, with the Chief Justice as chair. The council was given broad administrative powers over budget, technology, human resources, and numerous judicial branch operational strategies.
Utah's history with respect to a judicial council system, I like to describe it as an accidental solution to a number of problems. We actually had a very bifurcated, actually fragmented system of governance in place through the 60s and the 70s. The juvenile court had its own line item, was supervised out of the legislature. The district courts actually in the early 70s created what they called a judicial council, and they even got funding to hire a court administrator whom they called a state court administrator, but he had only authority over the district courts. And then the justice courts were completely off the grid. So we had a very fragmented system. The Supreme Court had never exercised much power in the administrative arena, and in fact had not been interested through the 60s and early 70s in exercising such power. It was not until the early 80s when the Utah Supreme Court discovered that the state needed an intermediate court of appeals, and that would require revisions to our judicial article in the Constitution, that they became interested in the judicial article. And once the article got opened, all kinds of people who had been concerned about this fragmentation, lack of leadership, inability of the respective systems to even talk to each other, let alone to agree on policy and planning issues, seized the opportunity to amend our Constitution in ways that permitted the creation of the Judicial Council. One of the things that was so impressive about our history in Utah is that, first of all, there was a lot of attention in the judicial article to creating the notion of a third branch of government. I have to say that prior to 1984-85, when the Constitution was changed, I don't think we had what you could call a judicial branch of government. We just had all of these freestanding trial courts with their own problems and problem-solving mechanisms. But once the Constitution was changed, the then governor put together what he called a Blue Ribbon Commission with stakeholders from the bar, from the judiciary, from the legislature, from public policy experts who were interested in the courts, people who really cared about the independence of the judiciary and its need to govern itself. And that Blue Ribbon Commission actually drafted potential legislation. It was a golden era. We had the support of so many wonderful legislators, as well as business people and others in the community, that it was a window of time in which we could get that legislation passed. And it was that legislation that created the Judicial Council in substantially the same form we have it now. And that brought together all the disparate elements in our judicial system. We created essentially a representative body with people from each of the court levels. We sort of backed the Supreme Court into governance where it had never been before by making the Chief Justice of the Supreme Court the head of the Judicial Council. So it's through that authority that the chief exercises leadership. We had enormous advantages in that respect, in that for many other states now contemplating a judicial council form of governance, it really means a lot of people have to give up a lot of power. And members of the Supreme Court sometimes, and the Chief Justice sometimes, are chief amongst those people who have to give up power. In our experience, nobody had much power to start with. So it was easier, I think, to construct our system. There's no question in my mind that the major benefit of a judicial council system is that it provides a mechanism for the judiciary both to act and to speak with one voice. So that when we deal with the other branches of government on budget issues, on policy issues, on legislative issues, we have a means of getting input across our system as to good policy, making a decision, and then sufficient buy-in with all of the trial courts and the appellate courts in the state so that the council speaks with authority and with clear authority to other branches of government. So that, and the other thing I would emphasize is the ability to plan. We can do phenomenal things with planning our own budgets and making our own policy decisions on how to spend our money. I think for those states who are contemplating moving to a judicial council model, there has to be absolute buy-in to some of the fundamental principles that underlie a judicial council system. One of which is this idea that the courts have to be able to speak with one voice. There has to be some kind of a centralized planning and policy-making body that has credibility and can be seen to represent the judiciary. So in every state, that poses different problems. Power resides in lots of places, and negotiating the sharing of power in a more democratic or representative fashion is extremely important, and I think most states who are looking at it have got to start at the grassroots level. They've got to be going to their existing judicial organizations, their existing court organizations, to the judges' associations, and start to create a shared vision, which it's very difficult. I don't want to minimize that. I feel very grateful that we kind of backed into it somewhat by accident, but it has served us incredibly well. The level of credibility that we have, particularly with the legislature and particularly on financial issues, is a direct result of our ability to have rational and authoritative decision-making power in a single body. Well, one example that comes to mind probably will resonate with many of the people at this conference, and that's the issue of court reporters. When we reached the determination that audiovisual recording equipment in our trial courts was an adequate substitute for live court reporters and was a much more efficient and less costly system of creating records, we were able, because of the authority of the Judicial Council, to examine that issue from a court-wide basis and to override, in the end, the individual loyalties. We only had one court in our state where court reporters had ever been regularly used. And they eventually had to come along and see that on the council, the people there were committed to what was best for the whole system and not to simply honoring the ties of loyalty and so on that individual judges felt to individual court reporters. We were also lucky on that issue that we've been able to make the change gradually because we had system-wide control, so that when court reporters had been leaving the system, retiring, and so on, we'd been able to phase them out, so that by the time we actually made the decision to go all the way with court reporters, there were relatively few left, and it was not a huge, emotionally wrenching decision. So I know how hard that issue's been in so many states, and I think our council system helped a lot. One of the things we never know about a system of governance is how it's going to adapt to the demands that are placed on it. The huge emphasis that we've had for the last 20 years in our council is building a culture where people who come to serve on the council understand that their job is not to bring home the bacon for their district or for their court level, that their job is to do what's best for the entire judiciary as a whole, and that will sometimes mean prioritizing budget items that won't help their court but will help another court that needs it more. And what I suspect is that that culture, which we've invested so much in, is going to become stronger over time because it served us so well, because we've done so well with our budgets and our legislature, and because it enabled us to survive the Great Recession better, I think, than most states in the country, in the sense that we were able to re-engineer, to use the term of art, to downsize in terms of personnel, to replace it with electronic services, so that we could save money but not diminish services. So I can't predict any specific changes that we'll want to make, but I suspect that our culture is going to become increasingly settled, and that we'll see, well, frankly, we haven't for years seen instances where people, really push back hard and try to go rogue, so to speak, where decisions of the council are concerned. We seem to have a good enough feedback loop within the judiciary that people who are disgruntled about decisions have a way to bring their discontent out into the open and get it addressed.
Now we'll do Chief Justice Blatz.
The Minnesota Judicial Council, I believe, rose out of necessity. I was appointed Chief Justice in 1998, and at that time we were getting momentum, moving from a very scattered funding structure in Minnesota. We had county funding, basically, a couple districts, we have 10 judicial districts, a couple of them were state funded, and we were in this movement to a state funded third branch of government. And yet our governance had most of the power rested with the Chief Justice, the general supervisory powers for the entire judiciary. And we had, by appointment of an earlier Chief Justice, a conference of Chief Judges with some advisory authority to the Chief Justice. And we then, of course, had an intermediate court. And we had 87 counties and 10 judicial districts. And we had no really formalized mechanism of governance. And the Judicial Council enabled us to work together, collaborate, and move forward with our new funding structures and everything else that we had to do. Well, it's easy for me to say that the Judicial Council rose out of a necessity, but let me tell you, it was not created by necessity. What happened was, we just recognized, and I would expand it from just me, because I did have an intercourt advisory group that I had appointed to help me govern the judiciary, but which also had representatives from all three levels of the court system and administration. But what I did is I didn't really want to come up with, first of all, the idea by myself, because I don't believe that that would be the best idea, and it would be very, very, very difficult to sell. So right from the beginning, I pulled together and formalized the process, and that was by appointing a transformation work group. And the transformation work group had people from, again, the Supreme Court, Court of Appeals, trial court, and administration. And they came together, and I asked them, what should we do with our new state-funded structure in Minnesota? How should the judiciary be governed? And they just jumped in, and I don't want to represent that it was easy all the time. It was bumpy. First of all, change is very difficult, and you can put a full stop on that, especially in a branch of government that takes so much of what we do by looking behind us. When we decide cases, we're looking at old law. That's just what we do. Plus, change is difficult anyway. So to take people who are accustomed just with things going as they are, to get them to work together to come up with a completely new way of governing the judiciary was very challenging. They were up to the task, so they were fantastic people. And they worked mightily for months, and then I was a member of that work group, but I did not vote. They recommended to me what they thought the governance structure should be, and that was the blueprint then for the Judicial Council. Well, I have to tell you that I was Chief Justice for 8 years and judge for 12. And when I look back at my career and the things that I worked on with other people, I would definitely put this as one of the top two things, two endeavors that I was engaged in with others. And I think it was so worthwhile. Change is very difficult, and a new governance structure in a judiciary for a state is not for the faint of heart. It takes everything you've got, you need to put on your seatbelt, and you need to go through the bumpy road, because you have to build trust. You know, as people told me, I had a lot of friends, and I still have friends, which is a good sign from having done this, but they'd say, you could say, well, people are mistrustful, and I'd say, well, why is that? Or distrustful. And they would say, well, why are you sharing your authority? What's the catch that we're missing? But the truth was, it's more like the emperor has no clothes, or Oz behind the thing. No Chief Justice, other states have different organizations, no Supreme Court. Nobody can administer a whole branch of government without the cooperation and energies and good thinking of all the different parts. And so I just think the Minnesota Judicial Council builds on the best that we've got. And it removes the smoke and the mirrors, and a Chief Justice sitting back there going in their own privacy of their office probably saying, help, removes all that smoke and that, and just formalizes the structure. It builds trust, because now people really know who is the body that is making the administrative policies. And the body itself is not an individual, and it's not people there who are just for representing a constituency, but one of our principles always was that we are there for the good of the order, really for the people of Minnesota, but we govern the judiciary. And that's just more than words. It takes a while sometimes for the buy-in, but when you have people who are a part of it, you can do things that you could never do before. And over time, I think that has proven to be true. And I believe the Judicial Council, with all the good people that are involved with it, will be here a lot longer than I will be on this earth. And maybe they'll improve it. I hope they do, if there's ways to do that. But I think the idea of people working together versus everything being driven by a person, be that Chief Justice or maybe even a little bit bigger body, a Supreme Court or a small group, is going to prove in the long run that that is the better model. And I'm just hoping other states replicate it, because I think it is sound and good government. Well, what happened next was a lot of work, but it was fun. The transformation members themselves, they went back to the districts. I was very much involved with this too. We went back, we answered questions, we explained it, and eventually what we got was a buy-in through a vote by every judicial district. And then that would be at the end of about 2004, and we then did not implement the Judicial Council until July of 2005, which allowed us 6 months to transition in a very orderly process. Every work group, from HR to technology to the budget, everything was calendared and planned in an orderly transition, so that on the day that we started, the Judicial Council actually had a body of work within its ambit at that point. And it took an incredible amount of planning, but it was really time well spent.
I discovered that you're either sleepy or we're not otherwise moved, but I appreciate your patience. I've got about 3 or 4 more minutes. To me, the most significant change occurred from the mandate that the new council reached to include people who would consider themselves obligated to the system rather than to represent a constituency. This emphasis was not taken for granted just because it was announced. It was effectively built into the responsibilities they accepted in joining the governing council. Whether or not the council is as developed in Utah and Minnesota will reach and maintain a comprehensive management mission may still be up in the air. To me, this is a subject we have not addressed. The long-term effectiveness of the councils will depend largely on the ability of state court administration to provide the staff work the councils need. Many of you are familiar with my favorite definition of a committee. A committee is a group of people gathered together to compound their ignorance. It is possible for a council to become a committee, especially if the staff work is defined by the wishes of a dominant chair. The chair-court administrator relationship, if at all, can in time revert to stacking the deck of the subcommittees and meetings in a way that ignores the built expertise of cross-sections of participants that have been designed into the council. In a meeting of court managers, I don't expect to encounter resistance to the assertion that an effective court administration is essential to a comprehensive development of program. The administrator must have genuine sensitivity to the purpose of courts, the legal and management process, and to understand the decentralized elements of the system. In the workshop session on judicial council governance immediately after this program, we will have a chance to explore some of these ideas here. The workshop will feature the Minnesota model, since it is easier for other states to implement via an administrative order. In the workshop session this morning, we will have a chance to explore some of the ideas expressed in more detail. You've been marvelous. Thank you.